ladies and gentlemen, it is now my very humble pleasure to get this webinar started. Of course, my name is Barak Mluka, and it is my very humble privilege and indeed pleasure to play the role of your moderator during this very important webinar. The webinar is coming to us under the umbrella of LawAfrica, and LawAfrica, as we are aware, are leading legal and paralegal content developers and a publishing outfit in East and Central Africa. So on their behalf, and especially on behalf of the Managing Director, Flavia Laria, it is my pleasure to welcome the panelists as well as the other participants. We are looking forward to a very robust session of just slightly over 2 hours. We are already 14 minutes inside the starting time, and I do hope and pray that we can all stretch out a little so that we could cover for that time that has already been consumed. I see that we have a very good presence of participants. The numbers are just skyrocketing. So far, we are standing at 296 participants, which is very good, and it's a tribute, I think, to both the topic and the kinds of speakers that we have on the panel. The matter before us is the matter of reflection on the supreme law of the land, the Constitution of Kenya, 2010. 10 years later, what kind of decade have we had? That is what we are going to be reflecting about. We remember that about 3 decades ago, the conversation on the Constitution occupied the minds of Kenyans in earnest, as we talked about the need to review the Constitution. There are those who said, no, the Constitution is all right. There are those who said, let it be done by the public. There are those who said, let it be done by Parliament. We remember the Ufungamano initiative. We remember the rifts that we had. We remember the Professor Guy-led Constitution of Kenya Review Commission, and we remember the efforts to reconcile the country around one effort to look at the Constitution afresh. We remember the 2005 fiasco before we eventually got a new Constitution in the year 2010, and which was promulgated on the 27th of August 2010. So 10 years later is an astute moment for us to reflect about the Constitution. How well is it serving us? What are the hopes? What are the impediments? What have been the opportunities? Have there been some losses in the process? So such are some of the issues, besides very many others, that we are going to be reflecting upon this afternoon. As we do so, I will once again request my technical team here to kindly try to assist Lady Justice Nancy Baraza, because she is on the phone using her phone item appliance, and I think it's not very stable, and we do hope that we can get more stability from that platform. And so we are privileged to have a very eminent professional.
Yes.
Lady Justice, could you kindly mute your microphone? Yes, just mute your microphone, Lady Justice, for now. Thank you very much. Yes, as we were saying, we have got 4 prominent legal minds very respected professionals in law, indeed I would even say scholars in law, and the people who have served very well in various capacities and continue to do so. They're going to lead us in this reflection. And at some point, of course, we will have our rest of guests participating, contributing by way of asking questions, by the way of making their own reflection, helping us to think about the Constitution. We are hearing that we are again on the cusp of yet another constitutional moment. Is this the case? Many other thoughts. And Professor Gidu Muigai asks, is the Constitution still fit for the intended purpose? What are some of the challenges that have arisen since the promulgation of the Constitution? And such some of the concerns that Professor Gidu Muigai will be helping us to think about. And Professor Gidu Muigai is a senior partner at Mohammed Muigai LLP. He is a professor of public law at the University of Nairobi and the immediate former Attorney General of the Republic of Kenya. He is the author of several books, including Arbitration Law and Practice in Kenya, published in 2011, and his up-and-coming publication, Power, Politics, and the Law, A History of Constitution Making in Kenya, which we certainly look forward to interacting with very soon. Honorable Justice George Odunga is the presiding judge at Machakos High Court. He has formerly presided over the Judicial Review Division of Milimani High Court, Nairobi, chair of the Mediation Accreditation Committee, and a member of the Rules Committee, member of the International Refugee Law Judges Association Africa chapter. He has also written widely, including Odunga's Digest of Civil Case Law and Procedure. He was awarded the 2015 Law Society of Kenya Distinguished Award in the Administration of Justice and the 2018 Jurist of the Year Award. And I say welcome, Justice George Odunga. We are looking forward to listening to you very keenly. Professor P.L.O. Lumumba, who is, of course, a very close friend of mine, apart from all these other accreditations, is a lawyer and Pan-Africanist. He has authored several books on law and politics, including but not limited to the Constitution of Kenya, Contemporary Readings, an outline of criminal procedure in Kenya, swearing by Kenya, judicial review in Kenya, devolution in Kenya, and dozens of other books, I dare say some of which are. Introducing a very special person. I've left her last for best because she's actually my niece. I don't know whether you knew that when you are asking me to moderate. Honorable Lady Justice Nancy Baraza, the senior lecturer and chairperson of the Department of Public Law at the School of Law, the University of Nairobi. Dr. Baraza was the first Deputy Chief Justice and Vice President of the Supreme Court of the Republic of Kenya. She served as a commissioner with the Constitution of Kenya Review Commission and especially chaired the committee that crafted the Bill of Rights in our Constitution. She served as the Vice Chairperson of the Kenya Law Reform Commission from 2007 to 2011. She is a founder member of the Federation of Women Lawyers of Kenya and served as its chairperson between 1995 and 1998. And many will remember that Nancy Baraza synonymized at that time the quest for review of the Constitution of Kenya. She was one of the people at the very forefront of that initiative. She has been a legal practitioner under the firm name and style of Nancy Baraza and Company Advocates, and she has served as a member of Egerton University Council from 2007 to 2011, and was, of course, awarded the Order of Grand Warrior by His Excellency President Mwai Kibaki for her remarkable work towards humanity. And she currently consults for the United Nations. I think the resumes of these speakers are quite long. Some of them could run to hundreds of pages, but I think that that will suffice for today. And so straight to business, I will give each one of you some up to 10 minutes. If you could do it in less than 10 minutes, so much the better, to give us your headline thoughts. Many years later, the hopes, the impediments, the opportunities, the losses, the expectations, the fears, and where you think we are and we should be going. By way of the timetable that has been given to me here, I will come straight to you, Professor PLO Lumumba, and you have your 10 minutes. Please, over to you.
Thank you very much, Barack. Let me start by saying how glad I am to be in this conversation. And because of the time that is limited, let me speak to the subject that I've been assigned to, namely to look at what has happened since the promulgation of the Constitution and what steps we can take to deal with some of the issues that have arisen. You've given a short history, told us where we came from the 1990s through to the attempt in which we were involved in the year 2002, the Boma's draft. We also know how the Constitution came about as one of the 4 agenda items after the post-election violence and ultimately the promulgation of the Constitution in the year 2010. But it's important to preface my presentation by reminding those who are familiar with the Constitution review process that the process was based on an act of parliament, the Constitution of Kenya Review Commission Act, Chapter 3A of the laws of Kenya. And when we were sitting then, we had a clear understanding of what was required of us, so that in the month of March, the year 2002, the Commission did issue a document titled The Constitution of Kenya Review Process, Issues and Questions for Public Hearings. And these issues were distilled for the purpose of identifying the critical issue. And they touched on several areas. They touched on the sovereignty of the people. They touched on the question of citizenship. They touched on the question of the architecture of the legislature, people representation, the judiciary, natural resources, independent commissions, and many other issues. But I think what we want to do, and what I want to do in the next few minutes, is to isolate some of the critical issues that have arisen since then, in the knowledge that my colleagues will speak to other things. One of the critical issues that we knew was at the very bottom of these issues and in the front burner was that of human rights. And what we did in the Constitution, and when I say we, I'm talking about Kenyans, is to come up with a Bill of Rights that does not make a distinction between what was then called first generation rights, second generation rights, and some even talked about the group rights as the third generation rights. Those of you who are familiar with the Tehran Declaration know that it is now understood that rights cannot be categorized in that way. And the major planks of these was the recognition, for example, of the place of women. And we have seen that the judiciary has robustly tried to interpret the Bill of Rights in a number of areas. We have seen the group rights, such as the rights of the object. We have seen issues of consumer rights, which have arisen. In the recent past, we have seen the rights segueing, if you may, into the arena of people representation, and particularly the two-third gender rule. And we have identified that the current architecture of the Constitution, particularly if you read the composition of Parliament at Article 97 and 98, has not lent itself to the implementation of that particular constitutional prescription. And we know why. Because when we were making the Constitution, we were clear that if you had a mixed member proportional representation, rather than a first past the post kind of method, which is geographically situated, you would have a problem. And I think that going forward, that is an area that deserves attention. We have also recognized in the area of representation, Kenya's representation is indeed, we are 33rd out of 233 countries that are recognized. Kenya has one of the highest representation. In other words, some people argue that Kenyans are overrepresented. I'm aware that my good friend David Ndii does not believe it, but there are those who think that we have too many members of parliament, too many MCAs. Perhaps that is something that we will want to examine at a later date. Another issue that has a reason which must be teased out is how we have dealt with the question of devolution. We were very clear that you needed to decongest the center, and we came up with the devolution. We are all aware that in the early days, we thought that they should be economically viable units, and that is why the prescription for a maximum of 18 or a minimum of 14. We ended up, of course, with 47 units, which many say are not viable. I think that there is something to say about that particular area of the Constitution, and to rationalize that with the provincial administration. The early thoughts were that the provincial administration, as it was constituted, would be scrapped, lock, stock and barrel. But we then ended up with a situation where we are saying that it ought to be re-engineered in order to work harmoniously with the devolved units. I think that that also deserves attention. The other area which we don't talk about is the area of citizenship. We have now seen in the case of our appointee to Seoul in South Korea, where Parliament has taken the view that if one is a dual citizen, one cannot be appointed as an ambassador. These are things I think that ought to be dealt with as we examine the Constitution. The other area is the architecture of the legislature, and I'm acutely aware of the time, is the question of the executive. We chose what we describe as a pure presidential system. We can see we are grappling with it, and we are being told that there are thoughts which are saying we should go back to what would be a parliamentary system. Perhaps that is another issue that ought to be teased out. The other critical area that I think deserves attention is independent commission. Many of us will remember that we talked about the Commission for Revenue Allocation. And one would have thought that when you have created a specialized commission such as that, then it would obviate the need for the kind of debate that we have seen in the Senate, which begs the question, do we really need a commission for revenue allocation? The same argument can be put forth as regards the Salaries Review Commission. We have seen them being second-guessed by Parliament, and one would pose the question whether indeed we need these many commissions. And that brings me, of course, to chapter 15, which deals with this commission. The late Otieno Odek, Professor Otieno Odek, wrote a very beautiful article saying, or posing the question, whether the constitutional commissions have become a fourth arm of government. And I think that there is a need to look at those issues, need to look at revenue allocation, and need generally to ask ourselves whether 10 years down the line, there are issues that deserve attention in the following areas as I conclude. Whether we need to refine how we deal with dual citizenship and what rights accrue from dual citizenship, whether we need to look at the legislature and how we are going to configure it in a manner that deals with the gender question, how we are going to deal with the executive, and whether we think that the American, what is a fundamentally American presidential system ought to be rejigged, whether we need to look at the manner in which we constitute our judiciary and the Judicial Service Commission. These are issues that we ought to grapple with, whether indeed we ought to look at commissions or the independent commissions and how we want to deal with them. How do we want to deal with revenue allocation and how we want to deal with the question of provincial administration? And there is a sense which I want to conclude with those because my colleagues will have the occasion to speak to the other issues and the Q&A will also tease other issues. But my final word, this constitution deserves attention so that some of the heresies which were introduced by parliamentarians in the year 2010 ought to be purged so that it is neater, cleaner, and sharper. Thank you very much, Mr. Moderator.
Thank you very much. That was very good. You've completed with 1 minute to go. I think that is the way it should be done. And Professor PLO Lumumba has flagged a number of important issues which I think have been noted. There are questions of gender and representation. There are issues of whether we are not overrepresented, questions of devolution, whether it's working or not working. Are dual citizens lesser citizens? The architecture of the executive, the independent commissions, and other issues. And it is his view, if I read him well, that we could be patched on a constitutional moment. But let us have headline thoughts from the next speaker. In the interest of gender equity and balance, come straight to you, Honorable Lady Justice Nancy Baraza. I believe you're hearing me loud and clear. Over to you, your headline thoughts.
Thank you very much, Chair, and good afternoon, everybody. The Constitution of Kenya 2010 is a product of a very long winding journey, and Chair, you did point out the processes way back of the People's Commission, then chaired by the late Dr. Oki Ombaka, in which I served as a commissioner, a People's Commissioner, and the merger of the then Parliament Commission, headed by Professor Yash Palgai, resulting in the 27-member Constitution of Kenya Review Commission under the Constitution of Kenya Review Commission Act of 2000, amended backwards from 1998. So it was a long journey, but eventually we got the framework within which the Commission carried out the Constitution review process. It included a lot of consultations with the ordinary people in every corner of this republic, a lot of civic education, and the participation of the people was seen to be important because of what befell the Independence Constitution, because it was given to us, negotiated in Lancaster. People didn't participate, and it didn't last well. It was almost trashed through a lot of amendments. And late Professor Okoth Ogendo argues that one of the reasons why the Independence Constitution suffered that fate was its lack of autonomy. It did not enjoy the legitimacy of the people of Kenya. And so the 2010 Constitution resulted from a very robust exercise of involving ordinary Kenyans from all walks of life to participate. And so I do agree with Professor Lumumba that 10 years down the line, 10 years since the promulgation of the 2010 Constitution, there are areas which probably need revisiting, but my concern would be that people, or the people of Kenya, must be the ones who drive that process. We should not suffer the fate of the Independence Constitution, which was amended on the initiative of the political elite. And so that would be my first point, that as we look at issues which have arisen within the 10 years of implementation of the Constitution, we must ensure that the people of Kenya understand what's going on, and they are the ones driving the exercise. Now, I should say, within the 10 years, we've done well in some areas. For example, I think in the areas of legislation, I think implementation has been carried out. Under Schedule 5 of the Constitution, legislation was enacted under the guidance of CIC, the Constitutional Implementation Commission. So that has been done, except the legislation for the realization of the not more than 2/3 gender rule, which remains a sticking point. But on this issue, I just want to say that women participated in the entire process of constitution making, in the struggle even to get into the constitution making process, and they won the support of Kenyans to have the principle of not more than 2/3 gender rule entrenched in the Constitution. I believe that if there had been sufficient political goodwill, we would have gotten a framework, a legislative framework for realization of that rule. That hasn't happened. And I do agree with Professor Lumumba that within the current setup, it's not possible to realize the not more than 2/3 gender in parliamentary representation. So that is an area that needs to be revisited, but with caution, because the debates which are going on around women empowerment and women's participation in politics and in parliament in particular are not very encouraging. So whatever initiatives that go on targeting reform within that area, we must take into account the fact that people may misunderstand the rule and mess it up. It is entrenched, but if we can undertake reforms, but ensure that we don't lose it, then I think that is an area that needs to be looked at. Another area in which we've done well in terms of implementation, I would say the judiciary in its interpretive role has done well, the High Court especially. I think in exercising their power of judicial review, we have had very robust jurisprudence that breathes life into especially the Bill of Rights. We have good jurisprudence on socioeconomic rights, rights to shelter, on rights to education, rights to food, I think that it has been robust, and it has picked the spirit or fulfilled the spirit of the Constitution of requiring that the judiciary be purposive in interpreting the Bill of Rights. So there, I think we've done well, although the fact of sections of the country or the public trying to disobey or ignore court orders, I think that is worrying. That is quite worrying. I don't know if it will be a matter of reform, but it is a worrying trend when court judgments are disobeyed. So that has been a problem. And in the area of devolution, I think there are talks of reforms in that area. Initially, as Professor Lumumba has said, fewer units had been proposed, but we ended up with 47. But visiting people in those 47 units, they seem to be happy with that kind of setup. So as they look at the reforms, I think they should also look at what the Kenyans are happy with, so that we don't take away what could be working for them. The other area of concern, of course, is Chapter 6, which was very, very central to the entire Constitution. If we were really going to realize full implementation of the Constitution, then Chapter 6 really mattered. But it is sad that parliamentarians whittled it down. So probably that is an area we need to revisit because corruption is really what is standing in the way of realization of the goals of the Constitution, especially in meeting with the socio-economic rights of the Kenyan people. So I think as they talk about reforms, Chapter 6 needs to be revisited so that we strengthen it. I think those would be my points, and we can get others from the participants. Thank you.
Very good. Once again, quite within the provided time, and a number of important issues once again flagged there, particularly lessons on how to review the Constitution and how not to review the Constitution. Emphasis here in a very special way on the participation of the people, the role that the citizens play, from the lessons we have learned from the past to where we are in a new process today. And we're asking ourselves, can we have the people's touch? She's talked about, again, the need for the indigenous touch in the past. That absence did give us what would essentially be looked at as an offshore constitution in 1963. Critically, Lady Justice Nancy Baraza points out the need for us to appreciate also what is good in the Constitution, so that if we should go into the process of looking at the Constitution of Kenya afresh, we should not lose the gains that are there. Sometimes when we are trying to fix it, we end up misfixing it because we mess up that which was good. Political goodwill, also raised a question of gender rights and the gender rules. But we have also seen that the judiciary has been a lot more purposive on the working of the Bill of Rights. We will be coming back to this again. As we have said, the attendance is very good. We have got upwards of 460 participants, and there is need for us to go through the initial stages so that we can then open up the plenary to as many of these participants as possible. The first two speakers have had a hand in the making of the revised constitution of Kenya, as we've heard from them. And of course, Professor Githu Muigai was also a part of those processes, and indeed went on to serve as the first Attorney General under the new constitutional dispensation. I think it is an astute moment, Professor Githu Muigai, having also listened to your colleagues who have traveled part of this journey with you, having been the Attorney General who bore the brunt of the implementation process, and seeing even that as we are where we are today, we seem also to be having fresh challenges, particularly on the gender issues. We don't know whether Parliament is lawfully constituted or whether the truth is otherwise. Where do we go from here? Over and above other, as I have said, headline thoughts on the constitutional journey this far, and where to from here. Over to you, Professor Githu Muigai.
Thank you very much, moderator. And you please feel free to intervene if you can no longer hear me, because my internet is not very good as I am on the move. I want to thank the organizers for inviting me to make a few comments. And I want to start by reminding us that sometimes when we talk about the Constitution, we forget actually that there are two constitutions at any given time in any given country. Why do I say that? Because there is the Constitution with a big C, and that is the document. If you go to any country and you ask, where is the Constitution? They will give you a document, and that's the Constitution with a big C. Where is the Constitution with the small c? The Constitution with a small c is the pattern of political behavior around the Constitution with a big C. Now, those are not the same things. And if you really want to appreciate that point, you have to look at the United States of America. If you look at how government is running in the United States today and how it was running 5 years ago, there is absolutely no comparison. But the Constitution hasn't been changed. So why is there a pattern of political behavior that is so radically different from how it was 5 years ago? That's my first point. My second point is this. When we talk about the Constitution 2010, sometimes we give it a special identity, which I think is inaccurate historically, because what Kenya has had is a series of constitutional experiences. And the Constitution 2010 is the culmination of several constitutional experiences. And I want to remind us, for example, in the colonial times, we had the Littleton Constitution, the Lennox Boyd Constitution. We had Lancaster I, Lancaster II, Lancaster III. That's how we ended up with the independent constitution. The independent constitution didn't just happen. It was piecemeal over a long period of time. almost six, 7 years, if I recall correctly. So, what is my third point then? It is that there is a culture that builds around the Constitution, and that culture that builds around the Constitution sometimes is more dominant in defining constitutional behavior than the constitutional document itself. Now, as a result of that, there is one very dominant theme in the constitutional experience of Kenya, and it is this. Because power was legitimated by the Constitution, in our experience, power was legitimated by the Constitution. In the colonial times, it was enough for the colonial authority to say, constitutionally, this is not permissible, and therefore, this is not politically acceptable. It therefore became a very dominant theme of our political experience, and that the Constitution must be made to accord to what are deemed to be the political imperatives of the epoch, of the period. And therefore, this contestation that has been going on for now, going to almost 65 years, headed to 70 years, this contestation to make the Constitution reflect the politics is not going to stop now. It was there then, it has been with us, and it will continue. So what we need to do is to appreciate how we can moderate that process so that its excesses, the excesses of that process, are contained. Now, I was asked to answer one question, and now I will come to it. Is this Constitution today fit for purpose? No. Is this Constitution fit for purpose? No. Why? Because several aspects of this Constitution were enacted in a manner, even at that time, that was inconsistent with what was the general consensus. And I think you are familiar, and the audience is familiar with the Bomas draft, the Kilifi draft, the Naivasha draft, the referendum, and so on. So I do not need to go to that. So that if you look, for example, and I think Nancy has already talked about, but I'll come to it. What are the three things, what are the few things that concern me a lot about this Constitution? Number one is size. Size. It is, we wrote this Constitution without any regard as to how we were going to finance it. It is as if we had a blank check. Look at the size of Parliament. Look at the size of Parliament. Look at the size of commissions. Can you still hear me, moderator?
Yes, you are spot on. Carry on.
Okay. If you look at the size of Parliament, if you look at the number of commissions, if you look at the number of institutions built around the Constitution, they are so many, they are unnecessary, they are expensive. Look at, for example, go inside the county government. It is amazing. The county government is a reproduction of the national government. You have the head of the opposition, the head of the party in power. You have a speaker. You have a clerk. You have nominated, and you in the county government, you nominate until you finish topping up. So if no woman is elected, for example, you top up until the 2/3 is observed, and so on and so forth. So we have a wasteful Constitution. We needed a Constitution that was lean, that was mean, that was fit for purpose. Now, look at coherence. Look at coherence. What have we done? we've taken everything that, if you have a ministry that doesn't work, let's say it's Ministry of Education, then what you do is you create a commission for higher education in what should be the work of the ministry. If you have a Ministry of Justice that is not working, you create a gender commission, a human rights commission, 5 different commissions that should be the work that should be done by a functioning Ministry of Justice. If the Ministry of Finance is not doing its work, okay, create Salaries Commission, Revenue Commission, another. To my mind, we do not have a policy coherence inside this document. Now, look at, let me say 2 things about 2 other institutions, then I'll hand over back to you. Look at Parliament. Forget the size for the time being. It is probably one of the first parliaments in the world where the upper chamber is the bigger house. Yeah? In Kenya, the way Bomas drafted the Constitution, Senate was the upper chamber, the House of Lords, more reflective, more reconciliatory, more, if I may use that word, more mature. Now, as amended finally by the politicians, the National Assembly became the upper house, and Senate became an appendage that has to look for work to do, because seriously speaking, under the Constitution, it has a general blanket to look after devolution, but hasn't got the sort of work that it should be doing, in my opinion. If you look at the judiciary, we borrowed the South African model, and I want to join Dr. Baraza in agreeing that we have a better, more robust, better educated, more professional judiciary than we did 10 years ago. I concede that point. But look at how we have structured the judiciary. Employment and labor court, land court, and so on. What have they done? They've created a chaotic situation where if you have a judge in Kitale, because he's in the land court, he cannot take a murder plea. And because the judge in the general civil court is on leave, then you have people in remand and other institutions for long periods and so on and so forth. So I would myself want to revisit some of this issue. The gender issue has been spoken about. I worked on 3 bills when I was in Sharia House. They were all defeated. The one defeated on principle, we never even assembled. As you know, the rule is that you will not table a constitutional amendment bill until you have quorum, the quorum to pass it. We never had a quorum to debate the 3 bills. So this is a serious problem. It is one that requires attention. Finally, let me say something about the provincial administration. You see, as this problem of the provincial administration was packed as a to-do thing, that is, it was to be dealt with past promulgation. But we've never had a proper debate with exactly what we want to do. I personally sympathize with the position that the central government, with numerous functions within the counties, must be represented in the counties. So there will always be, in my opinion, a form of provincial administration. But what form it was eventually to take, it's still one of these outstanding and vexing issues. And sometimes you see this push and pull between the governors and the regional administrators and so on. So, to the question, is the Constitution fit for purpose? Largely. Does it require a revisit? Yes. When, how, by who? I don't know. Thank you very much.
Thank you very much, Professor Gideon Muigai. Of course, I get a little worried, and I believe many Kenyans with me, when we are not so clear about when, how, and by who. I do hope that this forum will be able to help us to appreciate the questions of when, how, and by who. And it does appear, listening to Professor Githu Muigai, who has been quite clear in his rendition, that the contestation about the constitution that we have and the constitution that we want is not a contestation that is about to go away anytime soon, if it ever goes away indeed. It would appear that every moment is a constitutional moment, because there are issues that are unfinished all the time. But he also flags out some very key issues, particularly on the wastefulness of the constitution that we have. We seem to have made a constitution thinking not so much about its functionality, but perhaps about assuaging certain interests, hence ending up with a very wasteful edifice where we should be having a lean, mean, and fit for purpose institution that we would call the Constitution. The distinction between the political behavior around the institution of the Constitution being in itself another strand of the Constitution has been flagged. The question of grotesqueness in the architecture, design, and functioning of the institution of Parliament, the two houses, which of them should be the upper house and the lower house, and indeed whether in our situation we could even talk about an upper house and a lower house, hence ending up with a context where one of the two houses seems to be an appendage of the other and groping around for space and for business. Other issues have been raised about the provincial administration, and which remains an outstanding and vexing issue over and above a number of other issues. The judiciary has come up for special mention, and I think listening to all the three speakers so far, and who function and operate, of course, as officers of the court, but not in the mainstream of the judiciary as such, it is appreciated that certain gains have been made in spite of another grotesqueness also existing there in the architecture and function, where we have had Professor Githu Muigai clearly delineate some of these challenges, that you belong to the Environment and Land Court, and therefore you may not be present to attend to urgent matters that pertain to other branches of the law, and such other concerns. It is a fitting moment for us to listen to Justice George Odunga, and Honorable Justice George Odunga has, of course, enjoyed a lot of praise, especially from the Fourth Estate, where I work, for being faithful to the Constitution in his epochal judgments that he's been making. We have also talked about the publications that he has been putting forth, and which do help even lay persons like myself to come close enough to appreciating matters law. It is time, ladies and gentlemen, that we listened to the Honorable Justice George Odunga. If you could kindly unmute your speaker, your microphone, and have your 10 minutes. Over to you, Honorable Justice Odunga.
Thank you very much, Chair. I hope that I can be heard well.
Loud and clear.
Yeah, sorry, I had a problem with my laptop, which is suddenly hung. So I've been forced now to use my phone.
As we can see you and we can also hear you loud and clear, fortunately.
Thank you very much. I'm basically going to talk broadly about the Constitution of Kenya 2010. A lot of issues have been covered by the other eminent panelists. This constitution has been held as a transformative constitution right from the preamble. It does emphasize on the ownership of the constitution as the people of Kenya by use of the phrase, we the people of Kenya, and then adopts what has been called the social contract clause in clause 1, the one that gives the sovereign power to the people and delegates some powers to the representatives. The restatement of the supremacy of the Constitution, principles of devolution, national values and principles of governance, comprehensive Bill of Rights, which upholds both negative and positive rights. And therefore, it is my view that what Kenyans intended to have was a clean break from the past and to chart a new future. The appreciation that sovereign power may be exercised by the people either directly or through their representative, in my view, was a recognition that the views that are held by the representative may not necessarily be in tandem with those of the people they represent. And therefore, it was deemed necessary in Article 10 to have a reserved power given to the citizens and the national values and principles of governance with respect to the principle of public participation. The Constitution again recognizes that we need to be our brother's keeper, whereas the principle of local standard has been in past resorted to bar Kenyans from propagating the view, what in their views are actions which violate the rights of others. Articles 22 and 258 has now expanded the local standard principle to permit citizens to be their brother's keeper where their rights are being violated or threatened with the violation. I must say that great strides have been made in implementing the Constitution in terms of jurisprudence on the court, as has been said. We have seen decisions made on devolution, the place of and its place in the Kenya governmental arrangement, the respective roles of the Senate and the National Assembly, the right to dignity, as was expounded in the Mruatetu case, the role of constitutional commissions, application of the principles of public participation, relevance of various statutes and statutory provisions in the current constitutional dispensation, the independence of the judiciary, the threshold for free, fair, and credible elections, amongst other issues. The devolution principle has opened up areas which had hitherto been perceived themselves as outside Kenya, though we still have teething problems with respect to the implementation of devolution. The gains, in my view, the gains clearly outweigh the challenges. In terms of reliefs, Article 2023 does empower the court in applying the Bill of Rights to give effect to those rights and to have them developed. In my view, in developing the law would include developing the remedies as provided for under Article 259(1) with respect to interpretation in a manner that promotes the purposes, values, and principles, advances the rule of law and human rights, fundamental freedoms, and also permits the development of the law. It is therefore my view that it is based on those provisions that the courts have developed a number of remedies, including what is known as structural interdict. Apart from that, the remedy of judicial review has now been placed where it rightly belongs. It is now a constitutional remedy as opposed to a common law remedy that it used to be. This must be so because that remedy of judicial review has been held by the courts to be a tool of justice which serves the needs of a society on a case-to-case basis. The courts do envision a future growth of judicial review in human rights arena, and where it's becoming clear that human rights will evolve and grow as the society grows. That said, it's my view that we are here to partake and reap the full benefits of this constitution. Affirmative actions are yet to be concretized. Although Article 2832 says so, the values and principles of public service, which in my view encompass inclusivity, ethnic diversity, gender parity, welfare of vulnerable groups. The periodic reports that we get from the commissions paint a grim picture of these achievements. Again, whereas the Bill of Rights provides for positive rights, it would seem that more emphasis has been made on the negative rights, more so the political rights. We are yet to see serious litigation on socioeconomic rights domain, yet that is where, in my view, the rubber meets the road for a majority of Kenyans, since those rights are the basis, while the rights that we do concentrate on, in my view, are basically superstructure. It is therefore my view that there's a need to deliberate and concerted move towards realization of the letter and the spirit of the Constitution as contemplated in Article 259. A Constitution, just like the speaking drums, may well be good on paper, but unless it speaks, it is of no use or little use to anybody. The energy of this Constitution must therefore be harnessed so as to better serve the needs of the people as envisaged in the preamble to the Constitution. Again, our Constitution enjoins each and every one of us to respect, uphold, and defend it. This therefore calls for vigilance on the part of each and every one of us. We should not just sit back and hope that things will go on well unless we are vigilant about protecting the Constitution. Otherwise, it will amount to abdication of our constitutional duty. The teething problems will however, be expected. There will always be tough wars between various organs of the government, but this, in my view, should not give us sleepless nights. Such wars, in my view, are basically an indicator of a maturing democracy. As long as the same do not lead to a stagnation of the democratization process or pull us backwards, the healthy divergent viewpoints must always be encouraged. We must, however, resist all attempts to relapse to the old constitutional order and always remember that this constitution did not come on a silver platter. It was a result of many years of struggle, during which people lost properties, limbs, liberty, while others paid the ultimate price. Sacrifices that were made in the years ought not be allowed to go down the drain due to the failure of vigilance on our part. It is only then that we will be able to truly say that justice is our shield and a defender, and only then will we be able to escape the wrath of the future generations. I thank you very much. I think I'll stop at this point.
Thank you. Thank you very much, Honorable Justice George Odunga. And alongside you as well, the other three speakers before you, Professors PLO Lumumba and Gidu Muigai, and of course, the Honorable Lady Justice Dr. Nancy Baraza. You've been very clear, you've been spot on, and the time has come now when we are about to open the forum to the plenary. We have had Justice George Odunga particularly placing emphasis on eternal vigilance, which has been flagged out as a responsibility for each one of us. It is recognized that tough wars will always be there. People groping for space, fighting for space, trying to acquire even more space and to protect that space. And we've been told that it's an indication of a maturing democracy. Healthy divergence of views must be allowed to obtain, that we will not muzzle each other. The minority will have their say, even as the majority have their way. And I've particularly picked the point on the Bill of Rights, the negative versus positive rights. And of course, I like your analogy of the speaking drums, that the drums may be nominated as speaking drums, but if they don't speak, they're just there in that appellation of speaking drums. So we must make sure that we breathe life into the law and that it is working, the judiciary doing its bit as the last firewall, and the rest of us doing what we need to do as our brothers, keepers, particularly now that the Constitution opens that space to us to be our brothers as keepers through expanded locus standi. We thank you once again, and we will be coming back to you intermittently. We will take a raft of questions from a number of people, and then we'll, of course, have the panelists responding. Some questions may be directed at individual panelists. Others may be of a generic nature and directed at the panel as a whole. For a start, John Gaturuku is saying that in the cases of defiance of court orders, such as the one made to the president for the appointment of 41 judges, what would you propose if we were to change the Constitution to resolve such a deadlock? Should these powers still remain with the president? And there are a number of other questions, even as we wait for the plenary to raise questions by raising of the hand, to which point the microphone will be given to you. But we have Kennedy Owidi, who says that given the challenges and the events that have transpired in the past 10 years of our Constitution, can we really say that the Constitution embodies the spirit of the nation? Professor Pierre Lumumba, Stanley Kinyanjui would like to know whether, as we strive to ensure the independence of the commissions, it is important to note that they do not have, to date, an enforcement mechanism of their decisions. Turning to the courts for adoption of such decisions as enforceable using the judicial mechanism is also a frowned upon practice. Given that law does not exist in a vacuum and that orders should never be in vain, what do you then suggest should be the practice? Should their functions stand suspended until the enforcement mechanisms are put into place? Karen Wahungu, question to Honorable Lady Justice Dr. Nancy Baraza. Is it her suggestion that we consider another means to achieving greater representation of women in politics? Looking at the various bills that have been presented before Parliament and the inputs of different scholars as well, does the answer lie in the strict adherence to the implementation of the 2/3 rule, or should we look into other methods that will lead to the achievement of equality progressively? I think I'll give us just two more. And then let's see whether we have any hands raised, barring which I will come straight to the panelists. is there a need to focus on issues that are more related to processes affecting delivery of services to the people, such as revenue allocation and public tendering, since the failure of executive and legislature in these aspects puts the judiciary under extreme pressure to do more than interpretation? And finally, from this segment for now, let us take this one by Abel Odongo Onyango, who says that constitutionalism in its complexion requires adherence to the Constitution and its principles. Constitution being the constitute of the instruments of government, it is therefore criminal for the government constituted by the same laws to blatantly disobey court orders directed by the courts, of course. What is the way forward? What can be done for this regime to obey the fundamental law of the land? And what are the legal, philosophical, and jurisprudential concepts in the modern level views of law to deal with such situations? I think that is quite a plateful. Before we pass the microphone around, could we have some responses to that? Perhaps beginning with you, Professor P.L.O. Lumumba, followed by Lady Justice Baraza, responding to the more specific questions that have been pointedly placed at your doorstep. Then we'll come to the other honorable panelists. Thank you.
Thank you very much, Barack. Let me, before I answer the question, invite the participants to read a very important document. This is a document that was generated in the month of September 2016 by the then Auditor General. The working group was appointed by Parliament on the 26th day of February 2018, and it mandated the Auditor General to undertake a socio-economic audit of the Constitution of Kenya 2010. Is a very rich document that speaks to quite a number of the issues that we have raised here as regard the impact of the Constitution. But now to go back to the question that has been posed to me, first, when we talk about constitutional implementation, we must remind ourselves that the Constitution in and of itself, and Professor Muigai has spoken to it, is not the magic wand. There must be a culture of respecting the Constitution. And that is what made my good teacher, the late Professor Hastings Wilfred Opinyoko Thogendo, to say there are constitutions without constitutionalism. So that culture is what we have yet to embrace. And that is why you see the executive arm of the government with very jaundiced arguments, ignoring clear court orders. It is going to take time, particularly when there is no culture of respecting these orders. But it is incumbent upon the judiciary to make findings that indict the executive when they don't obey court orders. And in the fullness of time, the culture will indeed begin to gain root. And as the Honorable Judge Odunga said, if the people are vigilant and they make demands of the political class, then they will begin to obey these court orders. The second issue that has been asked of me is the ability of Chapter 5 commissions to implement some of their decisions. The Gender Commission, the Commission on National Cohesion, which is not a Chapter 5, but in that class. Then you talk about the Ombudsman. There is a danger to give every other body what one may call executing powers. I hold the view that these institutions exist in a legal environment. First of all, I hold the view that the commission should be reduced, as my good friend, Professor Muigai said. And once you do so and you create clarity in what their functions are, you will find that they will function. Take, for example, an argument that I personally did embrace at one time, that EACC needed prosecutorial powers. There may still be merit, But if you look at the intimacy with which the ESCC is now working with the ODPP, you can see how institutions can begin to consummate their relationship in a manner that allows them to work seamlessly and effectively. And I hold the view that this is not a matter of constitutional or architecture, it is a matter of constitutional practice, which will bring out a culture that allows us to operate. I conclude by giving the example of Sweden. The institution of the ombudsman, which we borrowed from Sweden and which Sweden has given to the world, works seamlessly and effectively in that country because the culture is a culture of obedience to constitutional prescriptions. And I believe that we will get there. We are still a young constitution, and I can't agree more with Judge Odunga that as we go, we'll make baby steps, and you'll have people who belong to Egypt, and therefore they'll always want to take us to the flesh pot of Egypt. And it is our duty to tell them that we are headed to the promised land. But there will be many dangers in the desert as we sojourn and as we are headed to the promised land.
Seem to make, thank you, Professor Pielo, but do we seem to make one or two baby steps forwards and a couple of giant steps backwards? One is particularly thinking about disobeying court orders. And is culture enforceable without necessarily getting the people's vigilance to turn into the denomination of street protests? Are there alternatives of the eternal vigilance that we talk about? Or should we give up and perhaps vary the Constitution itself to remove some of the things that we would seem to be unable to achieve? I've had a question here given to Lady Justice Nancy Baraza about her suggestion whether we should consider another means of achieving greater representation. I think she can read it there on her screen. Lady Justice Dr. Nancy Baraza. Are you with us, Honorable Justice Nancy Baraza? Have we lost you? I don't see.
As you are looking for her, somebody has posed the question, Juliet, asking about the document that I mentioned. This is the report of the working group on the socio-economic audit of the Constitution, which was published in September 2016 as a result of the parliamentary mandate given to it on the 26th of February 2014. It was chaired by the then Auditor General, Edward Ouko, and you can find it indeed if you Google. If you can't find it, I have a hard copy.
Very good. Professor Githumuigai, could you speak to the questions that have been raised? And one is particularly concerned about talking about culture. Culture seems to be something that becomes entrenched and whose reversal can be very difficult. How do we get ourselves out of that quagmire of a culture of defiance, defying the court, when the court would, in our view, be what you'd call the last firewall? Professor.
Thank you very much. I think my contribution to that particular debate would be on the topic of civic education. For a man who has spent the better part of my professional life working in or around the Constitution, teaching it, writing it, arguing cases about it, I am most proud of one thing. I think that not only on this continent, this is not an African issue. Kenyans are among the most informed populations about these political questions. And I think that, as you are aware, many foreigners comment about the level of political discourse in Kenya and the sophistication of political discourse among ordinary people, not around politicians, among ordinary people. I think this has been a product of the debates that we've held around the Constitution, around the first referendum, around the second referendum, and around the new issues that are facing us presently. If we haven't won anything else, we have won this, that Kenyans are aware, they are engaged, they are informed, and therefore for me, I live in hope that what my distinguished comrade PLO calls, I think taking from Judge Odunga, the baby steps. These baby steps are critical and they give me faith, and I have no doubt that a culture is coming and there's a cultural change. And I tell my students that I take great solace in the knowledge that there are things that in the constitutional debates in Kenya are no longer on the table. They are no longer on the table, meaning we have fought about them, we have fought over many years about them, and we have resolved them, and we have decided this is not on. There can be no discrimination on the basis of religion, of ethnicity, of etc., etc., etc. Some things we've removed completely from the table, and I think that is important. Other things we have put permanently on the table and said we will continue to fight and debate about this issue until it's resolved. Equal distribution of resources, equal access to development. That issue is permanently on the table. There are many countries in which all these are taboo subjects. I call that a victory for our generation and for this constitution.
Very good. Indeed, Professor, I agree with you. We have seen the evolution of that which is called Bunge la Wananchi, and you find Kenyans assembled in street corners and other conjunctions where they discuss political, social, and economic issues of their country. Kenyans have that opportunity to ventilate. Is that ventilation translating into something tangible over and beyond awareness? We have seen that when we talk about civic education, some of those who have played a key role in the past have been civil society. But have we also witnessed during this dispensation of the Constitution of Kenya 2010 an effort to demonize civil society and its work, and in fact to use such pejoratives as evil society? How do we ensure that we do not reverse and negate the gains that have been made? Justice George Odunga, as you also tie that up with the questions that have been raised, before we go back to the panelists, if we will not have discovered the whereabouts of the Honorable Justice Lady Nancy Barasa.
Thank you very much, Chair. Without dealing with the specifics, defiance of court order is really unacceptable. The principle of constitutionalism requires that we adhere to the rule of law. And the rule of law requires us to obey the court orders. We have avenues for challenging court orders which we are unhappy with. We may not agree with all the orders given by the court, and those orders may not necessarily be correct. But there's the option of disobedience of court orders is a no-go zone. So I think we must be clear about that. That as a country, as a democracy, as a country that prides itself to be guided by the rule of law and the Constitution, we have no option but to comply strictly to the Constitution of Kenya, because this is the document that the people of Kenya promulgated to be a bridge between them and the people who govern them. I really do not want to talk much about the civil society. As such, I have myself made certain decisions on cases that have come before me, which have been brought by the civil society. And I don't think it's a matter where I need to really give an opinion on here, since some of those matters might still be finding their ways in the ladders of justice.
Indeed, we appreciate those limitations that are some of the issues that we may want to talk about being presently processed through the courts, and therefore we may not want to go overboard. I want to apologize that we seem to be having a slight hiccup with the microphone, and therefore we will request that we continue to populate the questions and the discussion platform with our thoughts, and we will do our very best to give as many of the participants as possible the opportunity to speak. Try to telescope the comments so that we do not take too much time, and even as I recognize that I'm myself taking quite a bit of time in my interventions, which I'll try to keep short. Anungo Kavele says that one Duncan Kennedy held the opinion that politics and the law are indivisible. Based on the past, clearly politics have played a crucial role in the development of law in the country. Politicians have played a huge role regardless of their knowledge in matters law. And he would like the panelists to address the effects of the politics of the day on the judiciary functions, on the judiciary's functions with regard to Article 160 of the Constitution, whether a people elected rather than an executive appointed judiciary would be more independent, and the role of an independent judiciary in the realization of the dictates of the Constitution of the day. Quite a complex question there, but I have no doubt the panelists get it. All panelists, Chapter 6 is not just any other chapter. However, do you think that Article 52A on the right of an accused person to be presumed innocent until proven guilty slows down the pace to realize the essence of Chapter 6 of the Constitution? And if so, how can the two be reviewed and harmonized to ensure that Chapter 6 is not rendered to be a mere chapter in the supreme laws of the land? I give you 2 minutes each on those questions. PLO?
Very quickly, the question about Article 160 on independence of the judiciary. There is a very interesting comment that was made by Dan Wadada Nagudere of Uganda, who is a legal luminary. He was commenting about a statement made by a young lawyer called Picho Ali. And this is what he said, that when all is said and done, I agree, and we all must agree with Picho, that there is nothing like independence of the judiciary, that the so-called independence of the judiciary is nothing but division of labor. Of course, I don't agree with that, Justice Odunga, but there is a sense in which a judiciary does not exist in a vacuum. And I can't agree with you more that if a country disobeys court orders, then that country is a giant headed to the rocks. And that is why it behooves the judiciary, when orders are disobeyed, to cite these individuals for contempt, even if you cannot send them to jail. But let the record show that the individuals were visited with some pain known to law. The second question that has been posed is about presumption of innocence. I can never, ever allow, if I'm the one to be allowed, to depart from that. It is easy to say when your neck is not on the chopping board, but it is incumbent upon us to recognize that presumption of innocence is critical and a major plank in a country that is governed by the rule of law. Perhaps what we can do is to expedite hearings so that people are punished expeditiously if there is available evidence against them. And thirdly, Mr. Moderator, somebody has posed the question about the basic structure of the Constitution. And I think it is the Indians who developed this concept very robustly. You will see in our own Constitution, there are entrenched provisions. And these entrenched provisions actually are teased out of the concept of the basic structure. And that is why amending them requires the people's involvement. But very lastly, I want to agree with somebody who is saying that you cannot legislate good behavior, but the law does limit the bad behavior. And if bad behavior is limited by the law, in the fullness of time, mannerless individuals will begin to behave in a manner that is correct, and ultimately we develop a national culture. And in 150 years' time, you will be amazed. Remember when Abraham Lincoln proclaimed the freedom of the slaves until 1963. People of color did not have freedom in the United States of America. It takes time. It is intergenerational. And what we are doing now is to play our part and to hand over the baton. What we don't achieve now will be achieved by our children and children's children. But let us play our part robustly.
Proclamation of Emancipation, 1863.
Indeed. And 100 years, you remember, Luther King Jr. was still campaigning against the laws in Alabama.
Okay, so is it okay that we should just be satisfied that we're making those baby steps? Justice George Odunga, you have 2 minutes, and then I think now the microphone seems to be working, and we will give our other colleagues the opportunity to be heard. But first, over to you, Honorable Justice Odunga.
Thank you very much, Chair. With respect to the issue of politics and law, there's a way in which you can say that these particular principles are intertwined. If you look at what I call the structural interdict, these are remedies which are mainly in the socio-economic sphere, where, for example, you are dealing with the right to adequate food. You know, these are not the kind of judgments, matters you can deal with and give a judgment and stop there. Because there may be a need for you to also take certain steps to ensure that your judgment is implemented. And therefore, it might be necessary, even after you deliver your judgment, to engage the other arms of the government to ensure that the decision that you've given is being implemented. And in that way, you can say that you cannot completely divorce law from politics. Because as you make your decision, those decisions are going to be implemented. Some can be implemented immediately. Some require to be implemented over a period of time, hence the need for supervision.
Indeed, particularly in a context in which we start developing thick skins and we become indifferent to the phenomenon of public opprobrium and the possibility that we lose all capacity to feel ashamed, and society itself loses the capacity to ostracize those whom we would clearly call miscreants and reprobates and other serial law breakers. But we have got back Lady Justice Nancy Baraza. Could you speak to that question of alternative ways of ensuring that we achieve gender parity in institutions, whether it's appointive or elective? If you are hearing us, Lady Justice Nancy Baraza?
I'm hearing you, sir. Sorry, I went off power. I've just come in. Just refresh me a little. I'll deal with the question.
Chair, you are mute.
You are mute. You are mute, Chair.
That is a cardinal sin by the chair. May the chair be forgiven. But Justice Baraza, the suggestion was made by yourself that another means of achieving greater representation of women in politics be considered. And we've been told that Parliament has made various efforts, but they have fallen through invariably. And what then would these other alternative means be? And additionally, Lady Justice Nancy Baraza, without wading into dangerous spaces within the precincts of the principle of sub judice, Parliament has made numerous efforts, as we are aware. Is it such a sinning institution? Can we condemn it wholesale? Over to you.
Thank you very much, Chair. I think for me the problem has been political will to push through legislation for realization of gender parity and gender equity in public participation. It is true, quite a number of bills were presented to Parliament, but then achieving the constitutional number to push through the legislation has been a problem. So that some members of Parliament decide to absent themselves when the voting comes or the debate comes, and that has been a problem. I think it is the attitude that Parliament has had towards gender empowerment. The debates themselves display quite a lot of negative thinking about empowering women in politics, in Parliament, in participation. So unless we do probably a lot of civic education to educate would be members of Parliament and the members of Parliament themselves to realize that realization of the not more than 2/3 gender principle is a constitutional requirement, which they treat as if it isn't. So first and foremost, most of them do not appreciate their role in Parliament. Most of them do not appreciate their obligations under the Constitution. So the problem is larger than just having those bills in Parliament. Most of them haven't come to terms with the fact that that principle needs to be realized. And that is why, Chair, I was hesitant, quite apprehensive at first, that if we take this whole question of the not more than 2/3 gender principle back to the people who may not have the benefit of civic education, then it might be lost altogether. If we get parliamentarians who are under an obligation to enact that legislation behaving the way they have behaved, then what would an ignorant public do? So the problem is large, but if there is a political goodwill, we can still get a framework for realization of that principle.
Before I go to the plenary, I think I must bring this into Professor Gedo Muigai's courtyard. Professor Gedo Muigai, you have had the onerous task of advising the political class, particularly on this issue. Is it a matter possibly of feelings of impunity, feelings of, so what will anybody do about this? Is it true that there is inadequate goodwill and by extension, therefore, impunity in Parliament because they don't believe that anything could happen to them? Professor.
Let me first start with the question of law and politics. All law implicates politics, but constitutional law in particular implicates politics in a very fundamental way because the Constitution is a power map. It is a map that is drawn to distribute power. Power is ultimately about politics. So I think we should put that to bed, that we shouldn't worry too much if politics and law seem to have intersections. They are congenitally, that's how they were intended to be. And that is why the Constitution, that is why in a constitutional democracy, you have provisions like the chapter on the Bill of Rights, etc., because they are intended to ensure that politics doesn't become a zero-sum game. Let me come to this very controversial question, which ordinarily I would not wish to wade into. The question of the observance of court orders. I think there are two sides to that coin, and one side has been spoken about, and I need not speak about it. But there is another very fundamental debate that we need to have. The more robust the judiciary became, the more the firmer and more independent the judiciary became, in my opinion, the more it overreached in some key areas. Judicial authority all over the world exists because the judiciary is respected as impartial, independent, unimplicated in raw politics or policy. Now, increasingly, for better or for worse, our own courts have moved further and further and further into the political arena. And you have now every day, it is in my time, when we were students, it would have been totally unheard of that a case can be filed where the question is, the Minister of Transport has determined that the optimum matatu on a Kenyan road should have a minimum of 18 passengers. And the court has said, no, Mr. Minister, why don't we make it 9? You see, that is not a judicial, it is not a matter amenable to judicial interventions. Unfortunately, there are many, many matters now where you find judicial intervention in policy/political matters, creating this contestation. Now, I don't hold brief for either the judiciary or for the politicians, but it requires all of us, especially the scholars, the academics, to begin to debate what are the proper parameters of judicial intervention. Not every grievance is amenable to judicial resolution. My neighbor looked at me in a hostile way. It's not a justiciable matter, and you cannot get an court order that directs your neighbor on how he should be looking at you when you meet at the gate. So I hope I don't trivialize that, but it is a real important part of this debate that is not being had.
Thank you very much. I've heard that in certain jurisprudences that how you look at somebody could actually get you to be jailed by the courts. But Justice Odunga, we will be coming to you. Just put this in the parking space because we'll give you the first opportunity to speak when we come back. Put this in the parking yard. Is the judiciary overreaching itself? That has come from AG Emeritus. We will be coming back to you. I'd like to request the participants to raise your hand so that you can also be heard. I think we can see your hand here. Mwamu James, I allow you to talk. Mwamu James. Yes, Mohammed James.
Yes, good afternoon.
Good afternoon.
Good. Now, I agree with Professor Gidwigai that perhaps the issue of public finance was not considered. If you look at the public debt as at June 2010, it was about 1.2 billion. That is 39% of GDP. Now, this year, the public debt has risen to 6.7 trillion, which is 65% of the GDP. Now, my question goes to Professor Patrick Loch Lumumba. Now, having been the secretary of CKRC that majorly midwife the Bomas draft that this constitution has borrowed from, don't you think that CKRC should take responsibility for a part of the problem that we face in terms of financing this constitution? The next question goes to Professor Gideon Wigai. If you look at the issue of the disobedience of court orders, the Attorney General is at the center of the storm. Don't you think that there was a mistake in including the Attorney General to sit in the JSC as a member of JSC, because he finds himself sometimes in a very conflicting position? Don't you think that if, for example, the BBI movement succeeds, that we should remove the Attorney General as a member of Judicial Service Commission and perhaps have another government officer sit there, but not the Attorney General, because he advises the President and he also advises the Chief Justice when he comes to the Judicial Service Commission? Thank you.
Chair, you seem to be mute again.
Yeah, it's mute. I don't know whether it's mute or malice.
Sometimes I find myself muted.
Can I respond to David?
Let's take David first. I think he has the microphone now, if I'm not wrong. David Lesinko?
Yeah.
Over.
Thank you very much. My question is with regard to the basic structure doctrine and whether the framers of Kenyan 2010 Constitution really did envision the basic structure doctrine, because it is my understanding, and Justice Odunga just quoted Article 1 of the Constitution on the sovereignty of the people. And my question revolves around amendment of the Constitution by popular initiative. It's my own argument that the people are the sovereign, and whenever issues of amendment of the Constitutions through a popular initiative arises, then throwing the ball back to the people who are the sovereign should not really raise a lot of questions, because the people can decide to amend the Constitution if they deem fit. In that regard, is it therefore a justiciable question for one maybe to approach a court of law seeking advisory opinion on such a matter, because I don't think you can really challenge amendment of a constitution by a popular initiative, because we understand that the people are the sovereign. Thank you very much.
But let's take one more. Belinda Akello. Belinda Akello, can you hear us?
Okay, now I'm able to unmute. Thank you very much, Mr. Muluka. So very interesting conversations, and I'll just steer a little bit away from politics and ask, with the theme of promulgating the new constitution, one of the new areas the Constitution 2010 has brought is the elevating the threshold of environmental matters to a constitutional level. Now, the judiciary has been a bit disappointing in trying to make new environmental jurisprudence, but around the world, constitutions that have actually adopted this kind of elevation have also gone ahead to give rights to nature, and have also been of the opinion from some that human beings are having too many rights. So nature should also have rights and value. I'd be very interested to hear from Professor, from all the panelists actually, on what your take is about the elevation of environmental issues to a constitutional threshold. Should it have been there? Should we remove it so that it's just a statutory matter? And maybe also from the Honorable Lady Justice, the role of women in appreciating environmental matters, and particularly at a constitutional level. Are we doing justice? Or maybe it's something that we should review in DBI and have it removed? Or for all the panelists again, as the other countries have done, should we also give rights at the constitution, or go the Ugandan way and just give rights of the environment in statutes? Thank you.
Very, very good. Environmental issues, environmental rights. Let's get back to the panelists, and I did promise that we would go back to Justice Odunga to unpack that question. Then we'll come back to the rest of the panelists on the rest of the array of questions that have been raised. Justice Odunga?
Thank you very much, Chair. The issue of the judiciary overreaching itself, this is basically what I meant when I was talking about the tough wars. When you have the kind of constitution that we have, the Constitution of Kenya 2010, that is definitely different from the other constitution, the one that disperses power among different organs, the judiciary, the executive, and of course the commissions. You expect to find a situation where some organs might not be very comfortable about the manner in which particular organs are exercising their mandate. You may also find that certain organs may actually be moving a little bit beyond their mandate. That's very possible. You can't rule that one out. These are situations which are expected.
Those institutions, Justice Odunga.
Yes.
Is the judiciary one of those institutions that could be gravitating beyond its mandates?
It's not very easy to say that the judiciary is getting beyond its mandate. Because you see, the thing is that you have to look at a decision, each and every decision, and look at it on its own merit. To say that the judiciary as a whole is getting out of its mandate may not be fair to the judiciary. However, the point I'm making is that with time, these organs are going to get their space. They'll know where their space is. The judiciary, the executive, and the legislature. It's going to take us some time, a bit of some time to do that, but we will be there.
Very good. Professor PLO?
Let me very quickly just advert to the environment question, which is one that is out of step. Then I come to James Mwamu. Belinda, you will remember that the question of environment has preoccupied the world since, the Stockholm Declaration of 1972 and the 26 principles. From Stockholm, we moved to Rio, to Kyoto, then to Paris. And even if you want to go outside of the fauna and flora and you go into the oceans, you go into the Law of the Sea Convention. There is a sense in which we must read our Constitution in the context of those international principles which really take time to be cascaded down. And I will invite you, if you're not already familiar with them, some of the great work that is being done by way of activism by Friends of the Earth in Europe. And I think go basically to Stockholm. And these are some of the things that I think our judiciary should familiarize themselves with. And I'll not go beyond that because of time. The second more specific question to me is the one that is posed by my good friend, James Mwamu. James, remember that the CKRC generated a draft. And if you look at our draft, which is a draft of March the year 2002, that draft has very different provisions relating to public finance. Our CKRC draft was then debated at Bomas and produced the Bomas draft. The Bomas draft was converted into the Kilifi, sometimes eponymously referred to as the Wako draft. The Wako draft, then, of course, as you know, we were removed at that time, and then we ended up with the 2007, and we ended up with the harmonized draft. The harmonized draft was also affected by the interventions of the political class at Naivasha. And what you have as Chapter 12, which deals with public finance now, is in many philosophical and fundamental ways different from the original prescription by the CKRC, which was very sensitive to the public debt. And one of the reasons why I think that this is very critical, look at some of the things that were prescribed. Number one, introduce Commission on Revenue Allocation. Deal with salaries through the Salaries Commission. Split the Office of the Auditor General and have control of budget. All these things were done in the belief that if you were on the ball all the time, then you would not allow Parliament to run amok in the manner that it has. And I know now, courtesy of COVID, Parliament will say, but we are dealing with extraordinary times. But I cannot go, sorry. I cannot go further than this because this is something that I think requires quite some time. But I believe I make myself clear by saying that the CKRC, like Caesar's wife before it, is beyond reproach in these matters.
Very good. Lady Justice Nancy Baraza, you have been specifically mentioned and requested to say something about environmental issues.
Thank you very much, Chair. Participation in realization of the rights envisaged in the Constitution is recognized, and therefore women, through policy and legislation, should be able to participate in environmental conservation. And of course, the right applies to everybody, and participation is envisaged by everybody. So I think that can be done through policy and legislation. I don't know to what extent that has been done. Environmental area is not my strongest, but I believe that women should be able to participate in matters environmental.
Very good. Honorable AG Emeritus.
I'm afraid I'm not very competent on the last topic of how environmental justice can be expanded, except to say that I have been working with the UN Working Group on Business and Human Rights, and I know that there is increased awareness among businesses, and I think this is a very good beginning because businesses are some of the worst environmental degraders in the world, especially extractives. But there is an awareness now that is gaining ground to get business to appreciate that they don't just exploit the environment, they are responsible for restoring the environment. And to that extent, I think that this is an interesting horizon that we in Kenya ought to be getting in tune with. Thank you.
Thank you very much, Honorable AG Emeritus. We have been allowed a few more minutes by LawAfrica so that we could take a few more questions from the plenary. We'll take 1 or 2 rounds of questions, after which we will wrap up. And
Barack, if you permit me,
yes,
there is a question that has been posed, which I don't think we have spoken to, on the significance of Chapter 6.
Okay.
And just a single line, I think that Chapter 6 is critical on leadership and integrity. And I think we have not done justice to that chapter. And the Honorable Justice Odunga, this is the one area that I think a lot more judicial activism, for want of a better expression, could be much more present. And I've been very impressed in the recent past by the judgments of Justice Mumbi Ngugi in terms of how she has articulated this area. But in terms of the elections, I know for a fact that the EACC sent a raft of 100 plus individuals who ought not to contest elective positions. But the IEBC rejected, because they said that unless you are convicted, of course, we cannot stop you from running. I think that something more ought to be done as we look at Chapter 6, because it is the window that allows certain scoundrels, if you may, I'm looking for a good word to say a bad thing, I can't find it immediately, allows scoundrels to get into positions of authority and lawmaking. And that is detrimental to our society. I believe that my other colleagues may have something to say about Chapter 6.
Very good. They will subsume that into their subsequent answers. But just now, James Mbugua, you have the microphone.
Yes, my question really was basically supplementing what had been asked earlier, I think by David. And there's this sense that the people, or through their sovereignty, can make any amendments to this constitution. So I really wanted to ask exactly how far does this part go, and do we have a basic or an irreducible, non-derogable minimum? And I give an example. For instance, if we go to plebiscite, would we, for example, be allowed to vote on the citizenship status of, say, the Tugen, and say, because these guys are not that many, and we have the numbers, we can vote to strip them of their citizenship, or similar such, questions that may be posed, because theoretically, I believe any questions with regard to what is in this constitution can be posed in a referendum and put to the people. So that is what I want. How are we going to discover the basic cost structure that may perhaps be irreducible, a Hans Kelsen sort of, situation? Thank you.
Good. I think that the panelists have got that. Minority rights, context of plebiscites, how do we protect those? Leon Kipkemoi, you have got the floor, if you may speak.
Hello, can you hear me?
Loud and clear.
Oh, yes, so I'll be brief as possible. So my question is on the issue of independent commissions, and I'd like to pose these questions probably to all the panelists. Can we say that the constitutional independent commissions are a fourth arm of government? And secondly, can we say that the constitutional independent commissions are really independent, given the fact that recently we saw that they were given an ultimatum of 21 days before they could give their reports? Just that's my question.
Very good. I think I'll take one more. Jared Okeno. Okay, we've got Oliver Tangara. Oliver Tangara. Can you hear us, Oliver?
Yes, I can hear you, Mr. Barak.
Thank you. Proceed.
Yes, thank you again. My question goes to Honorable Justice J.V. Odunga. When at the beginning he mentioned something about he's not hearing people do litigation on social and economic rights. I want to ask him what is his take on the recent demolitions that are happening in the country of people's homes, and yet when these individuals bring cases to court and maybe court orders are issued, they are disobeyed. What is the way forward, or what should these people do? And some of them even make attempts to go to file petitions, public petitions in the National Assembly, but nothing is done, or even give some form of reprieve for them.
Thank you very much. I know I said that was the last one for now, but let's have Angela Mwikali. Angela, are you there? Angela, ask to unmute. Angela? Angela, we can't get Angela Mwikali, but there's Angela Sholei. There are two Angelas. The Angela Sholei. Someone technical, can we get some technical support here a bit so that we can get Angela Sholei speaking?
Thank you for the opportunity, but I think it was Angela Mwikali who wanted to speak, but I want to say I appreciate the discussion going on, and it's insightful for me.
Very good. Angela Mwikali, are you back? All right. Somebody, if you see Angela Mwikali, tell her we are looking for her. But meanwhile, back to the panelists. Could we start with you, Lady Justice Nancy Baraza?
Thank you, Chair. I think probably I can talk to the issue of litigating on socio-economic rights. Socio-economic rights are central to development, and they are rightly protected under Article 43 of the Constitution. And a few cases have come up, good jurisprudence. I think the Meter Bell case, which was decided by Lady Justice Mumbi, I think it set good precedents on the issue of housing. And therefore, these sometimes violent demolitions are running counter to what the court has actually ruled. So that before you demolish, before you scatter people from where they are, the question should be, where are they going? Are you providing alternative accommodation for them? I think that has been ruled on very, very brilliantly by Lady Justice Mumbi. And probably, I think, as Justice Odunga says, there needs to be more litigation, public interest litigation in that area. Another point on commissions. Commissions, I would agree with my former secretary at CKRC, Professor Lumumba. The commissions, if you go back to our original draft, CKRC draft, I think we had just 4 commissions. But when we reached Bomas, then they morphed into 15 and 16. Everybody wanted a commission. But now I think that is something that can be revisited. We just had 4 commissions. As to whether they are serving their purpose, there is a lot of debate. People are complaining there are too many. They are, sharing responsibilities which could be done by only one. of them. And as to their independence, again, there are questions which are being raised as to whether they are serving the original purpose of being independent at all. We hear complaints that they have been infiltrated by cartels so that they are no longer independent. So there are those issues. But in my view, there are just too many.
Over and beyond that, Lady Justice, may I please just give you 2 minutes to give us your final thoughts, and I will go to the other panelists. Really, we are a little bit overwhelmed. This has been quite something. There are so many questions there, but we cannot possibly address all of them. The plenary will have to forgive us, but let us hold on to get the closing remarks from the panelists as they speak to their latest schedule of questions. They will also give us their closing remarks. And so, since we are still with you, Honorable Lady Justice Dr. Nancy Baraza, maybe you could give us your closing reflections.
Thank you very much, Chair. I think 10 years down the line, we have many lessons to learn as we've tried to implement the Constitution. There are things we have done right. There are things we have not got right. And we have learned lessons so that if there are genuine initiatives to relook at the Constitution, I think that is something that can be addressed, but that should be something that Kenyans themselves should participate in. It should not be an elite initiative like what happened to the Independence Constitution. And then there are some gains that were entrenched in that Constitution. So as we talk about revisiting the Constitution, there are those gains we should not let go because the debate out there, the politics out there have changed. And in mind, I have the not more than 2/3 gender principle. And I want to tell Kenyans, the debate is that women want free things. Women don't want free things. Gender parity and gender equality in public participation in decision making is good for our own development. It is good for the country in the sense that women, men bring different sets of values which put together can help us make good decisions. So let it not be seen like women want free things, and that is a principle that should be preserved at all costs.
Thank you very much, Honorable Lady Justice Dr. Nancy Baraza. Honorable Justice George Odunga, respond to the last set of questions and also give us your closing thoughts.
Thank you very much, Chair. The issue of the socio-economic rights, as Lady Justice Nancy Baraza has stated, we have had a number of determinations made in that particular area. My view, however, is that we are not there yet. There are a number of rights that are not being litigated in court that need to be litigated. They need to be brought to court. We have made decisions on the issue of demolitions, the issue of the rights to housing. The problem is that the judiciary does not have the power to execute its orders. That's the main problem that we have even when we are talking about disobedience of court orders. You make orders, but then they have to be executed by somebody else. So when that execution is not being done, the only thing that you are left with is the issue of contempt of court. Again, contempt of court is very restricted because you can only jail or fine. So you find that your powers to execute those orders are rather restricted. It is something that I don't know what can be done about it, but that is the problem that the judiciary finds itself in. It can't execute its order the way it feels they should be executed. My last word is simple. This is our constitution. It is our document. We are bound to protect it and uphold it. We really do not have any option about that. If we feel that there are certain areas that are not right, the option is to correct them. But there's no option apart from that. There's no option that we are given to disobey it. We all state officers hold their position by virtue of the Constitution, and they have an obligation to protect it and uphold it. That's what I can say.
Spot on, Justice, and thank you very much. Coming to you, Professor Piero Lumumba, respond to those issues and also your closing remarks.
Thank you very much, Barack. Let me answer the question on the basic structure. And because of want of time, I'll remind the questioner to read the opinion of Hans Kana. Hans Kana is the person who popularized the concept of the basic structure, which allows the Indian Supreme Court to strike down an amendment that affects the basic structure. You see a semblance of it when you read our Article 255. It says certain provisions cannot be amended without going back to the people. So that when you read Article 255 and read 256 and 257, it speaks in a particular way to the questions you are asking. But of course, the conception of the basic structure a la Indian Supreme Court does not apply stock and barrel to our circumstances. I also want you to read a very good article published on the 9th day of November 2018 by a lady called M. Loughlin. It's in the International Journal of Constitutional Law, called The Silences of the Constitution. And it's important because the Constitution does not have to speak to everything. I think those read properly will guide you in terms of appreciating the concept of the basic structure. My final remarks. There is a beautiful Kiswahili saying, chako ni chako kikioza kikaushe. There is a sense in which our Constitution has good things and there are areas where it requires attention. I am of the considered view that those areas have actually been isolated in the UCO document of 2016, and we too, during this particular conversation, have identified those. People involvement is key, and if those issues are identified, then it is necessary to relook at the Constitution and to make it better. And I think that this is an opportune time to do so, and I can't agree more with my good friend, Dr. Nancy Baraza, that it must not be an elite exercise. It must be a people-driven exercise, as we determined for ourselves very early on during the process of making the Constitution. Thank you very much, Mr. Moderator.
Thank you very much, PLO. AG Emeritus, Professor Gidu Muigai. Take it home.
Let me make a comment about the basic structure. I think to just go slightly beyond where PLO has stopped. I understood one or two of the commentators to be suggesting that a public initiative, the citizenry, can amend the Constitution in any manner that they may wish. That is not true, because that would not be an amendment. The public, the citizens, are themselves as constrained as Parliament or any other person. For the same reason, if you are amending, it means that you are changing in a manner consistent with the fundamental assumptions of what you are amending. So if you wish to write an entirely new constitution, you must get out of this space. And that's the Kelsenian jurisprudence on it. And we fought a big fight about it, if you remember, in the case of Timothy Njoya. Many of you are familiar with it, and that argument was debated there for a long time. And maybe when we have another webinar, we will go into that. Finally, my own thoughts about where we are. I take great comfort, as would many people of my generation, that when we first got involved in this public space, our demands, our calls, our requests were very basic. We started with, please remove detention without trial. I cannot believe how far we have traveled, and that is why I will never lose hope. We have traveled so far because within a decade, less than a decade, we went from please remove detention without trial to bring back multipartyism. And inside a decade, we need a brand new constitution. So I do not think we should be very, very harsh with ourselves. We have done well. We have made mistakes. We are learning from those mistakes. The fire is burning bright, in my view. Otherwise, this webinar would have had no attendant. Thank you very much, Mr. Moderator.
Thank you very much, Professor. Thank you, all the panelists, Professor Githu Muigai, Professor PLO Lumumba, Honorable Lady Justice Dr. Nancy Baraza, and of course, Honorable Justice George Odunga. You have done all of us proud, and thank you for keeping the candle flame burning. You have reassured us that it is our constitution. You have reassured us that we have come from a difficult place, that the journey is ongoing. It's not going to end tomorrow. It is a relay indeed, and that at some point, current generations will pass the baton on to future generations, and that this effort must be ongoing. And of course, for their part, LawAfrica, as content developers and publishers of matters legal, will continue playing their role, and we are assured by Flavia Laria, the managing director, that this has just been the start of what they purpose to be quarterly webinars, where they're going to continue sourcing towering figures in matters legal leadership for us to reflect upon in sessions such as today's. And so on behalf of all of us, I've been privileged to be your moderator and anchor, Barak Mluka. So I say, have a very good evening and stay well, stay safe until we meet again another time.
Thank you very much.
Thank you.
Thank you very much, Chair.